Under the Tariff Act of 1883, US customs officials were required to classify imported goods to determine the correct duty. The Act specifically listed vegetables in their natural state as subject to a 10% ad valorem duty. Fruits were either not taxed at all or taxed at a lower rate, depending on the type. John Nix and Company was one of the largest produce merchants in New York City at the time. They imported a variety of perishable goods, including large quantities of tomatoes, which were increasingly popular with American consumers. The company sought to reduce its overall costs in an era when tariffs significantly influenced food prices. The customs collector in the Port of New York, Edward Hedden, consistently classified tomatoes as vegetables, applying the higher duty. Nix and Company formally protested these duties, arguing that the scientific definition of fruit was clear. A fruit is the seed-bearing structure formed from the ovary of a flowering plant. To support their protest, Nix and Company cited botanical authorities and dictionary definitions describing tomatoes as fruits. They submitted these materials as evidence during proceedings. They claimed that common misunderstanding or culinary practice should not override precise scientific classifications, particularly when interpreting statutes that affected commerce. The legal challenge was not merely theoretical or trivial. Tariffs on produce significantly impacted wholesalers' profit margins. By winning this classification battle, Nix and Company could set a precedent reducing costs not only for themselves, but for other importers of tomatoes. Initial legal proceedings began in the US Circuit Court for the Southern District of New York. When that court ruled in favor of the customs collector, maintaining the classification of tomatoes as vegetables, Nix and Company appealed the decision. The case ultimately reached the United States Supreme Court, which granted review to settle the dispute over the correct legal interpretation of the Tariff Act's language. The precise legal question before the Supreme Court in Nix v. Hedden was whether, under the Tariff Act of 1883, imported tomatoes should be classified as fruits or vegetables for the purpose of applying the duty. The dispute centered on interpretation of statutory language. The Act itself did not define fruit or vegetable, leaving the terms to be understood in their ordinary meaning. Nix and Company argued that tomatoes were, by scientific definition, fruits. In botany, a fruit is the ripened ovary of a flowering plant, usually containing seeds. This definition was well established in academic sources of the time. During the proceedings, Nix and Company introduced botanical dictionaries and standard reference works as evidence. These defined fruit to include tomatoes, alongside other seed-bearing structures like cucumbers, squash, and beans. Their legal team maintained that statutory language should be interpreted with precision, using objective scientific definitions to ensure fairness and consistency in customs enforcement. The United States, represented by the customs collector Edward Hedden, countered that the words fruit and vegetable in the Tariff Act should be understood in their common everyday usage. In the marketplace and in culinary contexts, tomatoes were typically served as part of the main course, not as dessert or a sweet dish. Consumers and merchants generally treated them as vegetables. During trial-level testimony, witnesses were asked how the terms were used in ordinary trade and by the public. The government presented evidence that tomatoes were universally sold and cooked as vegetables, reinforcing its claim that Congress intended the common meaning to control tariff classifications. The court's task was to determine which meaning of the term should govern. The scientific definition advanced by the importer, the ordinary trade and consumer usage relied on by the Customs Office. The resolution of this question would set precedent for interpreting statutory language in customs law, especially when scientific and everyday meanings diverged. On May 10, 1893, the United States Supreme Court delivered its unanimous opinion in Nix v. Hedden, ruling in favor of the customs collector. The court held that tomatoes should be classified as vegetables for purposes of the Tariff Act of 1883. Justice Horace Gray authored the opinion of the court. The decision rested on the ordinary meaning rule in statutory interpretation. The court reasoned that when Congress uses a term in legislation without defining it, the word should be understood in its common, everyday sense, rather than in a technical or scientific sense. Justice Gray noted that while botanically speaking, tomatoes were classified as fruits, that was not how the word was generally used in trade or daily life. He observed that in everyday language, fruit is typically associated with the dessert course, eaten raw and sweet, while vegetables are generally served with the main part of the meal. The court cited prior legal principles supporting reliance on popular usage when interpreting statutes that regulate commerce. To illustrate the issue, the opinion included testimony from lower court proceedings in which witnesses, produce merchants, were asked how the words fruit and vegetable were used in trade. These witnesses uniformly described tomatoes as vegetables in the context of buying and selling. Justice Gray's opinion also addressed the role of dictionaries. Both sides had introduced dictionary definitions, but the court found these confirmed the difference between botanical and common usage rather than resolving it in favour of the scientific definition. Ultimately, the court held that the Tariff Act of 1883 should be applied according to the understanding of the importing public and merchants at the time it was passed. Under that interpretation, tomatoes were subject to the higher duty imposed on vegetables. The Supreme Court's ruling affirmed the judgment of the lower court, maintaining the customs classification of tomatoes as vegetables for tariff purposes. This ended the importer's attempt to claim the lower fruit tariff rate. The immediate effect of Nix v. Hedden was to uphold the existing customs practice of taxing imported tomatoes at the higher vegetable rate under the Tariff Act of 1883. Importers like John Nix and Company continued paying these duties, which affected wholesale produce pricing. The case set an important precedent in statutory interpretation, emphasizing that when Congress uses common words without defining them, courts should apply their ordinary, everyday meaning instead of technical or scientific definitions. This principle has been cited in later cases involving tariff classifications and other statutes where trade or popular usage diverges from specialized terminology. Nix v. Hedden is occasionally cited in legal opinions and academic writings as a clear illustration of the ordinary meaning rule. It demonstrates how courts approach interpreting ambiguous or undefined terms in legislation, particularly in commercial and regulatory contexts. Beyond its legal impact, the case became famous as an example of quirky legal history. It is often referenced in law school classrooms and popular writing to highlight the sometimes surprising questions courts must resolve. The case's straightforward, almost mundane subject matter, the classification of a tomato, stands out against the backdrop of more consequential constitutional and criminal law cases, typically decided by the Supreme Court. Despite its obscurity among the general public, Nix v. Hedden is remembered in legal circles as a classic teaching case. It underscores how the legal system resolves disputes over language, and how seemingly simple words in statutes can generate litigation with real economic consequences. Today, it is often summarized with the phrase legally a vegetable, reflecting the court's reliance on practical and culinary understandings over botanical precision in determining tariff policy. Next, we have the 1886 story of the United States versus Kagama. In the late 19th century, the United States government was pursuing a policy of increasing control over Native American affairs, while simultaneously encouraging westward expansion by settlers. This period was marked by the reservation system, under which tribes were forcibly relocated to specific lands managed by federal agents. Tribes were recognized as domestic dependent nations under US law, meaning they retained certain forms of internal self-government but were also under federal oversight. The balance of power between tribal authority, federal authority, and state authority was a source of constant tension. A key development was the passage of the Major Crimes Act of 1885. This law gave federal courts jurisdiction over certain serious crimes committed by Native Americans against other Native Americans on reservations. The 7 listed crimes included murder, manslaughter, rape, assault with intent to kill, arson, burglary, and larceny. Congress passed this law in direct response to Ex parte Crow Dog of 1883. In that case, the Supreme Court had held that federal courts had no jurisdiction over a murder committed by one Native American against another on tribal land if the tribe had its own means of resolution. That ruling affirmed tribal sovereignty over internal matters, which angered federal policymakers who believed tribal justice systems were inadequate or too lenient by their standards. The Major Crimes Act was designed to override this result by placing those serious offences under federal jurisdiction, even within reservations. It was a clear assertion of federal power over tribal criminal matters and marked a shift in US Indian policy toward greater control. The specific crime at issue in United States v. Kagama was a murder committed on the Hooper Valley Reservation in California. Kagama, a Native American, was accused of killing another Native American on the reservation. Under the Major Crimes Act, federal authorities charged Kagama in U.S. District Court. Kagama's defense challenged the federal court's jurisdiction, arguing that the Major Crimes Act was unconstitutional. The core of the challenge was that Congress lacked the constitutional authority to impose federal jurisdiction over crimes between Native Americans on reservation land. The resulting case became a test of whether the Major Crimes Act itself was valid under the US Constitution. This central legal question in United States v. Kagama was whether Congress had the constitutional authority to enact the Major Crimes Act of 1885, granting federal courts jurisdiction over certain serious crimes committed by Native Americans against other Native Americans on reservations. Kagama's defense argued that the Constitution did not give Congress such power. They contended that criminal jurisdiction over offences between members of the same tribe on tribal land belonged exclusively to the tribe itself. This position rested on long-standing principles of tribal sovereignty, under which tribes retained inherent authority over their internal affairs, unless that authority was expressly limited by treaty or statute. They also argued that the federal government could not assume criminal jurisdiction over intra-tribal crimes without a clear constitutional basis. Specifically, Kagama's lawyers claimed there was no enumerated power in the Constitution that authorized Congress to legislate in this area. The United States government defended the act by pointing to Congress's plenary power over Indian affairs, a doctrine rooted in the Commerce Clause and in the federal government's unique relationship with Native American tribes as domestic dependent nations. The government argued that Congress had broad authority to regulate interactions with tribes, including internal criminal matters, especially to ensure peace and order on reservations. The case thus presented a fundamental constitutional conflict. On one side, the principle of tribal self-government, including the power to define and punish crimes committed by tribal members on tribal land. On the other, the federal government's claim of overarching authority to legislate for the protection of Native Americans and to maintain order within reservation boundaries. This legal question was significant because it tested the limits of tribal sovereignty under US law. A ruling upholding the Major Crimes Act would mean a major expansion of federal jurisdiction into the internal affairs of tribes, setting a precedent for further federal control over tribal criminal justice systems. The court's decision would thus determine whether Congress could override tribal criminal jurisdiction simply by passing a statute, reshaping the balance of power between the federal government and native nations. The United States Supreme Court issued its opinion in United States v. Kagama in 1886, upholding the constitutionality of the Major Crimes Act of 1885. The decision was delivered by Justice Samuel F. Miller and was unanimous. The court ruled that Congress did have the authority to enact the Major Crimes Act. thereby giving federal courts jurisdiction over certain crimes committed by Native Americans against other Native Americans on reservations. Justice Miller's opinion acknowledged that the US Constitution did not explicitly grant Congress a general police power to regulate crime within states or territories. The defense argument that no enumerated power existed for this jurisdiction was formally addressed. However, the court justified the act on the basis of the federal government's unique relationship with Native American tribes. Miller described tribes as wards of the nation, invoking the doctrine of guardianship. He argued that because of their dependent status, the federal government had both the right and the responsibility to protect them. He wrote that while the Commerce Clause might not directly authorize criminal jurisdiction over intra-tribal crimes, the power arose from the political relationship between the United States and the tribes, a relationship characterized by the government's duty to care for and protect Native peoples living on reservations within US territory. The court specifically rejected the idea that states had jurisdiction over these crimes. Justice Miller emphasized that states had no authority over reservations without Congress's consent. By contrast, the federal government's power over Indian affairs was considered plenary, meaning full and complete, though not unlimited, and derived from the status of tribes as dependent nations under federal protection. The opinion acknowledged the sovereign status of tribes but characterized it as limited and subject to federal control. Justice Miller framed the Major Crimes Act as an exercise of federal guardianship rather than an infringement of tribal sovereignty. As a result, the Supreme Court upheld Kagama's federal murder indictment under the Act, confirming that Congress could impose federal criminal jurisdiction over certain serious crimes committed by Native Americans on reservations, even when both perpetrator and victim were tribal members. This ruling definitively established that Congress could unilaterally extend federal legal authority into internal matters of tribes, marking a significant shift in the legal balance between tribal sovereignty and federal power. The Supreme Court's decision in United States v. Kagama had a profound and lasting impact on federal Indian law and the balance of power between the United States government and tribal nations. By upholding the Major Crimes Act of 1885, the ruling confirmed that Congress had plenary power over Native American tribes, even in internal criminal matters traditionally governed by tribal law. This doctrine of plenary power meant that Congress could unilaterally legislate on a wide range of issues affecting tribes without their consent. Kagama became a foundational precedent cited to justify further federal regulation of tribal affairs. It provided legal support for subsequent expansions of federal criminal jurisdiction on reservations. Over time, the list of crimes under federal jurisdiction would grow far beyond the original 7 in the Major Crimes Act. The ruling also contributed to the erosion of tribal sovereignty. By framing tribes as wards of the federal government, the court reinforced the idea that tribal self-government existed only at Congress's discretion. The language of dependency and protection became a legal basis for justifying federal intervention in tribal governance and justice systems. Kagama also influenced the development of the trust doctrine in federal Indian law. This doctrine holds that the federal government has a fiduciary obligation to act in the best interests of Native American tribes. While framed as protective, it has often served to justify broad federal control. Critics of the decision argue that Kagama institutionalized a colonial relationship, treating tribes as lacking full sovereignty and subject to unilateral federal authority. The case is frequently cited in legal scholarship as an early and clear expression of the tension between tribal self-determination and federal oversight. Despite its age, United States v. Kagama remains good law. It continues to be cited in modern Supreme Court cases and lower court decisions when questions arise about the scope of congressional power over tribal nations. Its reasoning has shaped over a century of legislation and jurisprudence, defining the relationship between the United States and Native American tribes. The next case is called the Slaughterhouse Cases, These cases arose during the Reconstruction era following the American Civil War, a period marked by intense debate over the meaning and enforcement of the newly adopted 13th, 14th and 15th Amendments. The 13th Amendment abolished slavery. The 14th Amendment, ratified in 1868, was designed to secure citizenship and civil rights for newly freed African Americans. Among its key provisions was the Privileges or Immunities Clause, which declared, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." This clause was intended to limit state governments' ability to infringe upon fundamental rights of citizenship. However, at the time, its precise scope was untested. Against this constitutional backdrop, the Louisiana state legislature passed a law in 1869 creating a government-sanctioned monopoly for slaughtering livestock in New Orleans. The act required all butchers in the city to conduct their slaughtering at a single, centralized location operated by the Crescent City Livestock Landing and Slaughterhouse Company. The stated purpose of the law was public health and sanitation. During the mid-19th century, urban slaughterhouses posed severe health hazards, contaminating rivers and spreading disease. By concentrating operations in one location subject to regulation and inspection, the city sought to improve sanitary conditions. Under the statute, independent butchers who were not part of the monopoly had to pay fees to use the facility. They could no longer legally operate their own slaughterhouses within the city limits. This legislative act sparked immediate opposition from local butchers. They viewed the monopoly as an unconstitutional infringement on their right to pursue their trade. Their grievances were not simply economic, but also constitutional, as they claimed the law violated the newly adopted 14th Amendment. These tensions between public health regulation and economic liberty, set against the transformative constitutional changes of Reconstruction, formed the background for the slaughterhouse cases. After the Louisiana legislature granted the exclusive slaughterhouse franchise to the Crescent City Company, hundreds of independent butchers were effectively barred from operating their own facilities in New Orleans. Instead, they were forced to rent space and pay fees to use the centralized slaughterhouse. Seeing this as an attack on their livelihoods, a group of butchers filed suit in federal court. They argued that the law created an unconstitutional monopoly, violating their rights as citizens to freely practice their trade. Their primary constitutional argument relied on the 14th Amendment's Privileges or Immunities Clause. Ratified only a few years earlier in 1868, this clause had never been definitively interpreted by the Supreme Court. The butchers' lawyers contended that being a citizen of the United States guaranteed them certain fundamental rights, among which was the right to pursue a lawful occupation free from arbitrary state interference. They claimed the Louisiana law abridged these privileges or immunities by granting a monopoly that excluded them from their trade unless they complied with onerous conditions. They also invoked other provisions of the 14th Amendment, the Due Process Clause, arguing that depriving them of their right to practice their trade without a fair process violated due process of law, and the Equal Protection Clause, arguing that singling them out for economic disadvantage while benefiting a single company denied them equal protection under the laws. However, the centerpiece of their challenge was the Privileges or Immunities Clause. They urged the court to adopt a broad reading of this provision, one that would protect substantive rights of national citizenship, including economic liberty, from oppressive state legislation. The legal question thus put before the Supreme Court was not simply about the fairness of Louisiana's monopoly, but about the meaning and scope of the newly enacted 14th Amendment. At stake was whether the amendment gave the federal government power to oversee and invalidate state laws that interfered with citizens' ability to work, conduct business, and exercise other basic civil rights, even when those laws were ostensibly passed for public health or welfare reasons. In 1873, the United States Supreme Court issued its landmark decision in the slaughterhouse cases, ruling 5-4 in favour of the state of Louisiana and upholding the slaughterhouse monopoly. Justice Samuel F. Miller delivered the majority opinion. The court rejected the butcher's argument that the Privileges or Immunities Clause of the 14th Amendment protected their right to pursue their trade free from state interference. The central holding was that the Privileges or Immunities Clause protected only rights that arose from federal national citizenship, not rights arising from state citizenship. The court held that most civil rights, such as the right to practice a trade or pursue a business, were governed by state law, not federal law, and thus were not secured against state legislation by this clause. Justice Miller provided examples of rights the court viewed as privileges or immunities of a US citizenship, such as the right to travel to federal seats of government, access to seaports, protection on the high seas, habeas corpus rights under federal authority. He concluded that these were narrow, specific rights of national citizenship, not general civil rights or economic liberties enforceable against the states. Regarding the due process and equal protection clauses, the court dismissed those claims as well. The majority found no violation of due process because the butchers were not being deprived of property arbitrarily. They could still practice their trade just under regulated conditions. As for equal protection, the court viewed the law as applying equally to all butchers in New Orleans, requiring all to use the same facility. Justice Miller's opinion emphasized federalism, preserving the balance of power between the states and the federal government. The court argued that adopting the butcher's broad reading of the 14th Amendment would make the federal judiciary a general overseer of all state legislation affecting civil rights, undermining states' traditional authority to regulate local economic matters. In sum, the court's decision narrowly interpreted the scope of the 14th Amendment, especially the Privileges or Immunities Clause, effectively limiting its power to restrain state governments. The Supreme Court's majority opinion in the slaughterhouse cases offered a foundational interpretation of the 14th Amendment that would shape constitutional law for decades. Justice Miller's reasoning was grounded in preserving federalism. He warned that if the Privileges or Immunities Clause were read broadly, as the butchers proposed, the federal courts would become the final arbiters of nearly all state legislation affecting civil rights and economic regulation. This, the court argued, would radically shift the balance of power away from the states and toward the federal government. By interpreting the clause narrowly, the court confined it to rights stemming directly from national citizenship, excluding the vast body of civil rights that traditionally fell under state police powers, the state's authority to regulate health, safety, morals, and general welfare. Miller's opinion effectively distinguished between two types of rights: privileges or immunities of United States citizenship, being narrow and federal in character, and civil rights belonging to state citizenship, being more broad and locally regulated. Under this framework, economic liberties such as pursuing a trade or occupation were classified as rights derived from state citizenship, meaning they could be regulated by state legislatures without federal interference, so long as they didn't violate other constitutional protections. The decision also limited the practical reach of the Due Process Clause and Equal Protection Clause in the specific context of the butcher's claims. By framing the monopoly as a health regulation equally applicable to all butchers, the court found no denial of equal protection. Similarly, requiring all butchers to use a central facility was viewed as consistent with due process so long as it wasn't arbitrary or confiscatory. Constitutional impact. The decision severely limited the scope of the Privileges or Immunities Clause as a tool for protecting individual rights from state infringement. By excluding most civil rights from its protection, the court left enforcement of those rights primarily to the states themselves. This narrow reading meant that, in practice, the clause provided almost no federal protection for civil liberties against discriminatory or oppressive state laws for nearly a century. The ruling shaped subsequent 14th Amendment jurisprudence. When courts later protected civil rights from state action, they generally relied on the Due Process and Equal Protection clauses instead, since the Privileges or Immunities clause had been rendered largely ineffective by Slaughterhouse. The Slaughterhouse cases had a lasting and significant impact on the interpretation of the 14th Amendment. By adopting a narrow reading of the Privileges or Immunities clause, the Supreme Court effectively stripped it of most practical force. After Slaughterhouse, that clause offered almost no protection against state laws that infringed on civil rights. This decision set a precedent that would endure for many decades. In the years following Slaughterhouse, the Supreme Court rarely used the Privileges or Immunities clause to strike down state laws. Instead, the court developed other doctrines to protect individual rights from state action, particularly through the Due Process Clause and the Equal Protection Clause of the 14th Amendment. One major consequence was the doctrine of selective incorporation. Starting in the early 20th century, the court began applying most, but not all, of the Bill of Rights to the states through the Due Process Clause, rather than the Privileges or Immunities Clause. For example, rights like freedom of speech and the right to counsel were eventually enforced against the states, but only through this alternative constitutional route. Legal scholars have often criticised Slaughterhouse for undermining the original purpose of the 14th Amendment, which was designed during Reconstruction to protect the civil rights of newly freed African Americans from hostile state governments. By limiting federal protection, the decision left states with greater freedom to pass discriminatory laws, including the Jim Crow laws that followed. Despite these criticisms, the Slaughterhouse interpretation remained the dominant approach for over a century. The Supreme Court only revisited the Privileges or Immunities clause seriously in the McDonald v. Chicago case in 2010. In that case, Justice Thomas argued in a concurring opinion that the right to keep and bear arms should be applied to the states through the Privileges or Immunities clause. However, the majority continued to use the Due Process Clause for incorporation, leaving Slaughterhouse largely intact. Today, the Slaughterhouse cases stand as a foundational precedent in constitutional law. They are often taught as an example of how the Supreme Court's interpretation of constitutional texts can shape, and sometimes limit, the scope of civil rights protection in the United States. Now we move to the case of Shelley v. Kraemer, 1948. In the early 20th century, racially restrictive covenants became a widespread tool for enforcing housing segregation in the United States. These were private agreements written into property deeds that prohibited the sale, lease, or occupation of property to people of specific races, most commonly African Americans, but also other minority groups such as Asian Americans and Jewish Americans. After purchasing the home in St. Louis, the Shelley family faced a legal challenge from Louis Kraemer, a neighbouring property owner who sought to enforce the racially restrictive covenant recorded decades earlier. The covenant explicitly stated that the property could not be occupied by any person not of the Caucasian race, except for domestic servants. Kraemer filed suit in Missouri State Court, asking for an injunction to prevent the Shelleys from taking possession of the property they had legally purchased. The Shelleys argued that enforcing such a covenant violated their constitutional rights under the 14th Amendment, specifically the Equal Protection Clause, which prohibits states from denying any person equal protection of the laws. The legal question was not whether private parties could make discriminatory agreements among themselves. Under traditional contract law, private individuals were free to agree to such terms. The constitutional issue arose from the role of state courts in enforcing those agreements. At trial, the Missouri court ruled in Kraemer's favour, granting an injunction to enforce the covenant. The Shelleys appealed to the Missouri Supreme Court, which affirmed the lower court's decision. The state high court held that such covenants were private agreements and that their enforcement did not amount to state action subject to the 14th Amendment. This interpretation created a critical legal conflict, whether state judicial enforcement of private discriminatory agreements constituted state action within the meaning of the 14th Amendment. The Shelleys, joined by civil rights organisations including the NAACP, argued that although private individuals could enter into discriminatory contracts, state courts could not constitutionally enforce them because doing so would amount to the state itself participating in racial discrimination. This question, whether enforcing a private discriminatory agreement in court is state action subject to constitutional limits, was the central issue when the case reached the United States Supreme Court. In 1948, the United States Supreme Court issued a unanimous decision in Shelley v. Kraemer, ruling that state court enforcement of racially restrictive covenants violates the Equal Protection Clause of the 14th Amendment. Chief Justice Fred Vinson delivered the opinion of the court. The court distinguished between private agreements, which individuals could technically make, and state action, which the Constitution regulates. The court held that while private parties could agree among themselves to discriminatory covenants, those agreements could not be enforced by the courts without implicating the state in discrimination. The critical reasoning was that judicial enforcement is state action. By granting an injunction to remove the Shelleys from their home, the state court was not merely acknowledging a private agreement. It was actively using the power of the state to deny them equal protection of the laws. Chief Justice Vinson wrote that the 14th Amendment erects no shield against merely private conduct, but it does prohibit discriminatory action by states. When courts enforced racial covenants, they effectively became instruments of state-sponsored discrimination. Therefore, state court orders enforcing these covenants violated the Equal Protection Clause by making the state complicit in racial segregation. The court reversed the judgments of the Missouri Supreme Court and companion cases from Michigan, ruling that such enforcement was unconstitutional. The decision did not invalidate racially restrictive covenants themselves as private contracts. Instead, it prohibited their enforcement in any court, making them legally unenforceable. This distinction preserved the principle that the Constitution restricts state action, not private bias alone. By declaring that judicial enforcement of racial discrimination was unconstitutional, Shelley v. Kraemer closed one of the main legal avenues used to maintain racially segregated housing in the United States. The Supreme Court's decision in Shelley v. Kraemer had an immediate and lasting impact on housing discrimination in the United States. By holding that state enforcement of racially restrictive covenants violated the Equal Protection Clause, the court effectively made such covenants unenforceable in any American court. This ruling closed a major legal mechanism used to maintain residential segregation, weakening one of the most pervasive tools of institutionalized racism in housing. However, the decision did not outlaw the covenants themselves. Private parties could still make discriminatory agreements, but they could no longer use the courts to enforce them. This meant that although the contracts technically remained in many property records, they became legally meaningless. The ruling also established a critical precedent in constitutional law by clarifying the concept of state action. It confirmed that judicial enforcement of private discrimination is itself state action subject to constitutional scrutiny. This doctrine would become foundational in later civil rights cases challenging discriminatory practices that relied on state support or involvement. Despite the decision, housing segregation persisted through other means, including discriminatory lending practices, which at the time was called redlining, real estate steering, and informal social pressure. Nonetheless, Shelley v. Kraemer removed the formal legal support of the state for enforcing racial exclusion in housing. The case is often seen as an early legal victory for the civil rights movement. It demonstrated the potential for the Supreme Court to dismantle aspects of systemic racism, and provided a constitutional principle that civil rights advocates would build upon in later cases. Today, Shelley v. Kraemer remains a landmark decision in equal protection jurisprudence and property law. It is taught as a key example of how the Constitution limits state involvement in private discrimination, and how the courts can play a role in advancing civil rights. The next case is of Yick Wo v. Hopkins. San Francisco experienced rapid growth driven by the gold rush and westward expansion. This period saw significant immigration from China, with Chinese labourers forming a vital part of the workforce in mining, railroad construction, and urban industries. As the Chinese population in San Francisco grew, so did racial hostility and discriminatory local policies. Many white residents and political leaders viewed Chinese immigrants as economic competitors willing to work for lower wages. This anti-Chinese sentiment led to social tensions and organised efforts to drive Chinese workers out of certain trades and neighbourhoods. One area where Chinese immigrants found steady work was the laundry business. Laundries required limited capital, were accessible to immigrant entrepreneurs, and provided an essential service in a growing city. By the 1880s, a large proportion of San Francisco's laundries were owned and operated by Chinese residents. Amid these demographic changes, the San Francisco Board of Supervisors passed an ordinance regulating laundries in wooden buildings. The ordinance required any laundry in a wooden structure to obtain a special permit from the board to continue operating. Ostensibly, the law was passed for fire safety reasons. Wooden buildings posed a greater fire risk, and the city argued that regulation was necessary to protect public safety. However, the ordinance did not specify clear, objective criteria for granting or denying permits. Instead, it left the decision entirely to the discretion of the Board of Supervisors. In practice, the board used this discretion in a discriminatory manner. Nearly all Chinese applicants were denied permits, while almost all non-Chinese applicants operating similar wooden laundries were granted them without difficulty. Yick Wo was one of many Chinese laundry owners affected by this law. He had operated his laundry in a wooden building for years, complied with all existing safety regulations, and had no record of violations. Despite this, his application for a permit was denied solely because he was Chinese. When he continued to operate his laundry without the permit, just as many non-Chinese owners were allowed to do, he was arrested, convicted, and sentenced to jail under the city's ordinance. These circumstances created the background for Yick Wo v. Hopkins, a case that would test whether laws that were neutral on their face but discriminatory in their application violated the Equal Protection Clause of the 14th Amendment. City records showed a stark disparity. Among approximately 200 laundries in wooden buildings, about 150 were owned by Chinese operators. Every single Chinese applicant was denied a permit. Meanwhile, out of around 80 non-Chinese applicants, all but one received approval. This enforcement pattern revealed that the ordinance, while neutral on its face, was used as a tool of targeted discrimination. The law granted sweeping discretion to city officials, who used that power to exclude Chinese residents from the laundry trade, a vital economic lifeline for that community. Yick Wo filed a petition in the California Supreme Court, arguing that the city's application of the ordinance violated the Equal Protection Clause of the 14th Amendment, which prohibits any state from denying any person within its jurisdiction the equal protection of the laws. The California courts rejected his claim. They held that the ordinance was valid on its face, and that local authorities had the discretion to enforce it as they saw fit. The courts did not examine the discriminatory pattern in the issuance of permits. This set up the central constitutional question when Yick Wo appealed to the United States Supreme Court. Does enforcement of a facially neutral law in a systematically discriminatory way violate the Equal Protection Clause? Is it unconstitutional for local officials to use broad discretionary power to target a specific racial group while exempting others? These questions would form the heart of the legal challenge in Yick Wo v. Hopkins. In 1886, the United States Supreme Court delivered a unanimous decision ruling in favour of Yick Wo. The court held that the Equal Protection Clause of the 14th Amendment applies not only to the content of laws, but also to their administration and enforcement. Even though the San Francisco Ordinance was neutral on its face, its application had been systematically discriminatory against Chinese laundry owners. Justice Matthews, writing for the court, stated that, though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority, with an evil eye and an unequal hand, it is a violation of the Equal Protection Clause. The opinion emphasised that no state or local government can use its enforcement powers in a discriminatory way. By denying permits almost exclusively to Chinese operators, while granting them to virtually all non-Chinese, the city had exercised its discretion in a racially biased manner. Critically, the court also held that the Equal Protection Clause protects any person, not just citizens. Yick Wo, though a non-citizen, was entitled to its full protections. The decision did not strike down the ordinance itself, but prohibited its discriminatory enforcement. It established that unequal application of a law can be just as unconstitutional as a discriminatory law on its face. This ruling set a precedent confirming that governmental fairness is judged by outcomes as well as text, enforcing constitutional limits on how discretionary power can be wielded. Yick Wo v. Hopkins became a foundational precedent for interpreting the Equal Protection Clause of the 14th Amendment. Its key legal contribution was establishing that discriminatory enforcement of a facially neutral law violates equal protection. This principle means governments cannot hide discrimination behind formally equal language if their actions systematically target a racial group. The ruling has been repeatedly cited in civil rights cases, including challenges to Jim Crow laws, voter suppression, and policing practices that showed patterns of unequal enforcement. It laid critical groundwork for arguing that state action includes not only legislation, but also the administration of laws. Yick Wo also reinforced the principle that constitutional protections apply to all persons within US jurisdiction, including non-citizens. This aspect has influenced immigration law and the rights of non-citizens in later Supreme Court decisions. Today, the case remains a cornerstone of equal protection jurisprudence. It is taught in law schools as a clear statement that government power cannot be used in ways that are covertly discriminatory, ensuring that constitutional guarantees of fairness are judged not only by the wording of laws, but also by their real-world application. Now, we will quietly jump ahead a century. The case of Georgia versus Randolph involved a dispute over police searches of shared homes when occupants disagree about letting officers in. The case arose in a domestic setting where two co-occupants both had authority over the home. Their conflicting responses to police, one consenting, the other refusing, created a legal conflict about how the Fourth Amendment's consent rule applies in shared residences. The central constitutional issue in Georgia versus Randolph was how the Fourth Amendment's consent exception applies when co-occupants disagree about allowing police to enter and search their shared residence. Under the Fourth Amendment, searches and seizures inside a home generally require a warrant, but there is a well-established consent exception. If someone with actual or apparent authority over the premises voluntarily consents, police may lawfully enter and search without a warrant. Before Randolph, the court had upheld this principle in United States versus Matlock, 1974. In Matlock, officers obtained consent from one occupant while another, who was not present to object, was detained nearby. The court ruled that consent by a co-occupant with authority was sufficient, even without the other's agreement, so long as the other did not object at that moment. This created a legal question about the limits of shared authority. What happens when two adults share common authority over a home, and one is physically present and expressly refuses consent while the other says yes? Can police rely on the consent of the willing occupant to override the objection of the refusing occupant? The question was important because it tested the balance between individual privacy rights and law enforcement's ability to obtain consent in multi-occupant dwellings. It asked the court to define whose decision controls when there is a direct simultaneous conflict. Lower courts had split on this issue. Some had ruled that any occupant's consent was enough regardless of objection, while others held that a present occupant's refusal should control. This inconsistency created uncertainty about how police could lawfully conduct consent searches in shared residences. Georgia versus Randolph brought this conflict squarely before the Supreme Court. Does one occupant's consent trump another occupant's explicit, present, and contemporaneous refusal? In Georgia versus Randolph, the Supreme Court ruled in a 5-3 decision that police may not conduct a warrantless search of a home when one physically present co-occupant consents, but another physically present co-occupant expressly refuses permission. Justice David Souter delivered the majority opinion. The court emphasized that the Fourth Amendment protects a reasonable expectation of privacy in the home. When two residents are both present and one objects to entry, that objection signals that entry is not broadly authorized by the household itself. The majority reasoned that social expectations shape what consent means in shared living spaces. It is not customary, the court argued, to treat one occupant's invitation as sufficient to override a co-occupant's objection when both are standing at the door. In ordinary life, if one resident says "come in" and the other says "stay out," a guest would recognize they have no clear invitation to enter. Therefore, the police could not claim that the consenting occupant's authority alone made the search reasonable under the Fourth Amendment, when the other occupant was present and objecting in real time. The ruling did not overturn earlier precedents like United States versus Matlock or Illinois versus Rodriguez, which allowed police to rely on the consent of one occupant if the other was absent or unavailable. The court specifically distinguished Randolph by the fact that both occupants were physically present and one was actively refusing. In dissent, Chief Justice Roberts and others argued that the majority created confusion and practical problems for police. They warned that the rule would encourage suspects to object simply to block searches, even when other residents were willing to cooperate. Nonetheless, the majority held firm. A physically present occupant's explicit refusal overrides another occupant's consent, barring police from conducting a warrantless search in such circumstances. This decision clarified a specific limit on the consent exception to the warrant requirement under the Fourth Amendment. Georgia versus Randolph set an important limit on the police consent exception to the Fourth Amendment's warrant requirement. After this ruling, law enforcement agencies nationwide had to adjust their procedures for consent searches in shared residences. Officers were required to recognize that a present co-occupant's explicit objection bars entry, even if another occupant consents. This clarified that shared authority is not unilateral authority when occupants disagree in real time. The decision did not ban all consent searches in shared homes. It preserved the rule that police may rely on the consent of one occupant if the other is absent or unavailable to object, as established in Matlock and Rodriguez. But it drew a clear constitutional line for situations where both occupants are present and one refuses. Law enforcement training materials began including Randolph as a critical Fourth Amendment standard. Officers were instructed to respect refusals from present residents and to seek a warrant if entry was necessary despite an objection. The ruling also influenced later legal debates about privacy expectations in shared spaces. It reinforced the principle that the Fourth Amendment protects individual choices about access to the home, even in co-occupied settings. By grounding its reasoning in social norms about invitation and privacy, the court's decision shaped how courts evaluate reasonableness in consent cases. While the decision was controversial for limiting police flexibility, it remains good law. Courts continue to apply it as a binding precedent when evaluating the constitutionality of warrantless searches in cases of conflicting consent. Georgia versus Randolph stands as a modern clarification of Fourth Amendment doctrine, demonstrating how the court balances law enforcement needs against the fundamental right to privacy in one's home. Well, that's all for tonight. If you're still awake, feel free to get comfortable and stay a little longer. The campfire will keep burning softly for you. Just relax, breathe, and rest as long as you need.